Hi, a very good evening to one and all who's joined us together for the Text in Context October edition. First up, we have Dinesh, who will be presenting on drafting patent specification. Over to you, Dinesh.
Thank you, Kavya. Hello, everyone. We will see about the basic and some of the approaches in drafting patent specification. So in the first page of the patent specification, we have the title of the invention. The title should not be more than 15 words. The title should indicate the subject matter. That is, the title should be relevant to the invention while not disclosing the invention. So let's take an example. So we have a energy saving ceiling fan. So in which the energy losses is significantly reduced. So here if we say that the invention lies in the stator, then the title can be drafted as a stator for a ceiling fan motor. If the invention lies in the rotor, then the title can be drafted as a rotor for a ceiling fan motor. If the invention lies both in a stator and rotor, then the title can be drafted as a ceiling fan motor. So here, if the application here, it can also be extended to others, then we can broadly keep the title as electric motor or electrical machine. And we need to avoid using fancy words, that is saying novel ceiling fan motor or high efficient ceiling fan motor should be avoided. Then we can mention about the applicant details, that is a name, address, and the nationality of the applicant can be mentioned. Next is a preamble. So if it is a provisional specification, then the preamble is the following specification describes the invention. If it is a complete specification, then the preamble is the following specification particularly describes the invention and the manner in which it is to be performed. So next is a technical field. Technical field is related to the technological domain to which the invention belongs. So here, let's take an example. The disclosure herein generally relate to engines and more particularly to forced air induction system for the engine. So here engine denotes broader technical field, while forced air induction system, it denotes the specific technical field. So background, next is the background is deals with the conventional systems. So here we can mention about the closest prior art, and we can write down the differences between the prior art and the present invention, and we can add the problems of the conventional systems. Next is the objects. So object is related to the solution to the problem, that is a necessity for the invention. So here we can mention the principal object first, then the secondary objectives can be listed down later. So here we can also include the technical advantages. So next is a brief description of drawings. So here this is a short description about the drawings that are attached in the drawing sheet. So the drawings will assist a reader to clearly understand the invention that is disclosed in the patent specification. So in the drawing sheet, it is always preferable to use line drawings than solid drawings, since it may be objected by the examiner. It can also include schematic drawings, block diagrams, circuit diagrams, and flowcharts. So next is a detailed description. So detailed description gives a comprehensive information about the invention in detail. So the detailed description should enable a person skilled in the art to recreate the invention, and it should also specify the best mode of operation, that is the working of the invention. So here we will see about one of the approaches in drafting detailed description, that is a flow in which the detailed description can be drafted. So first we can list down the elements that are present in the invention, and we can mention about the function and the applicability, and we can also mention about the other alternate applications. Then we can move on to the constructional details. There is each function of each element and the constructional detail should be explained in a sequencing manner as per the reference manuals. So next we can mention about the alternatives, that is the alternate embodiments. Then we can mention about the method. Later we can mention about the working of the invention, And at last, we can mention about the technical advantages of the invention. So next is statement of claims. So claims define the scope of protection for the invention. So it should have at least one claim. So there is no limitation on the number of claims. So claims should be supported by the specification. So here, whatever we are going to claim, it should have support in the specification. And whatever that is not claimed in claims, it will stand disclaimed. So let's say if we have a main feature which is not claimed in the claims and we have a reference to that in the detailed description, then bringing back the element into the claims, it will not be possible. So there are two types of claims. One is the independent claim, which is a broad claim or standalone claim. Next is a dependent claim, which is a specific claim, and it is dependent on the independent claim or the another independent claim. So these are some of the pointers to consider while drafting claims. So the claim writer, it should be broader, not only covering the present embodiment, but it should also cover the alternate embodiments as well. It should be drafted from the infringement perspective. That is, the claims drafted, it should not be easy for the third party to evade. So if let's say if the invention is not in a crowded art, then we can claim at least one element in the independent claim. So the number of elements that can be claimed in the independent claim, it depends upon the invention. And we can claim the principal novel elements in the independent claim, and the features of the principal novel elements or the secondary novel elements can be claimed in the dependent claims. And if we have sub elements, let's say that if we have a component and we have a sub feature in that, then the broad scope should be provided for these sub elements, so that evading the claim, it will be difficult for the third party. Let's take one example in drafting claim. So here we have a driving shaft and a driven shaft. So which is connected to belt and pulleys. So if we draft all the elements that are present, so in this manner, there is a driving shaft, a driving pulley mounted onto the driving shaft, a driven pulley mounted onto the driven shaft, and a belt adapted to connect the driven pulley to the driving pulley. So this gives a narrow scope of protection. So if we say that there is a chain and sprocket drive in place of pulley and belt, then this will be a limiting claim. So here we have a broad claim in which if we say a driving shaft and a driven shaft rotatively connected to the driving shaft. So this gives a broad scope of protection, and so we can claim the driving pulleys, that is belt and pulley drive, gear drives, and the chain and sprocket in the dependent claims. So next is merging multiple embodiments in a single set of claims. So here the example taken is a height adjustable vehicle having electric linear actuators for adjusting the height of the chassis of the vehicle. Second embodiment, it's about the usage of hydraulic linear actuators, and in the third embodiment we have the pneumatic or the mechanical linear actuators. So here we can if we maintain a single terminology, that is single broad terminology, let's say it's actuator, then we can cover all these embodiment in a single set of claims. Next is varied scope of protection. So here in the example, let's say that the vehicle, it includes element A, B, C, D, and E. And if we draft independent claim that is in vehicle comprising element A, B, and C in the independent claim, and element D and E are claimed in the dependent claim, then so let's say that if the third party wants to make use of element D and E, and in the vehicle he is not having the element A, B, or C, or if there is a modification in that, then it will be easy for the third party to easily evade the claim. So if we draft two set of claims, two independent claims, there is a vehicle comprising A, B, and C, and in another independent claim we have element D and E. So this will give you a very scope of protection, and it is a broad claim. And in example 2, we have an engine intake system includes air intake duct, air filter, and intake air manifold. So in the first independent claim, we are claiming all the parts of the air intake system. And in the second independent claim, we are claiming the air filters if it's having a novel feature. So here we are not only claiming at the system level, but also we are claiming at the part level. So this will give a wide scope of protection. So here we can catch hold of not only the OEMs, but also the vendors who supply the product to the OEMs. Next is abstract. So abstract should start with the title of the invention. It should mention the technical field and the principal use of the invention, and the solution to the problem should be mentioned, and the technical advantages can also be mentioned. And the relevant figure that is to be published, it should be mentioned in the abstract. And the total number of words, it should not exceed 150 words. This is one of the approach in drafting patent specification. So once we have a complete understanding about the invention, one can start drafting the claims first. Then the title, technical field, background objects can be drafted later. Then we can continue with the drawings. And if there are any revision in claims, we can revise it. And if it is not, we can continue with the detailed description. And finally, we can complete with the abstract. Thank you. Over to you, Kavya.
Thank you, Dinesh. Next up, we have Nikhil, who will be presenting on a recent Delhi High Court judgment titled FMC Corporation and Others versus Natco Pharma Limited. This case further discusses the principle of equivalence with respect to patent infringement. Over to you, Nikhil.
Good afternoon, everyone. I'll be speaking
hello,
about
I'm so sorry to interrupt. Dinesh is offline. May I ask a question to Dinesh? Is that possible? I think this is Nikhil.
Yes, sir. Dinesh is here.
Okay. So Dinesh, it was a lucid explanation of parts of the specification. Thank you very much. However, one question I have, which a lot of young drafters normally bring up, is which is the best approach to draft a specification? Should you start with the claims, or should you draft the description and different parts and then draft the claims? So what is your thoughts, or what are your thoughts on this?
Yes. So once the invention is clearly understandable by the person who is going to draft, then we can start drafting the claims first. So if the invention is not clear, then we can start drafting the other portions with the detailed description, and lastly we can come to the claims.
Okay, so what you're saying is, if you know all the elements and embodiments of the invention well enough, then you start with the claims. Otherwise, it's advisable to start with the description. By the end of it, you'll understand the technical details well enough to be able to draft claims. Is that what you're saying?
Yes. Yeah.
All right. Thanks, Dinesh. That's it. Thank you.
Thank you.
Thank you, Dinesh. Thank you, sir. Nikhil, you may share your screen. Hello, Nikhil.
Yeah. Good afternoon, everyone. I'll be speaking about the recent Delhi High Court case, FMC Corporation and ORS versus Natco Pharma Limited. So the plaintiffs FMC Corporation and FMC Agro Singapore Private Limited were assigned an Indian patent that was for a method for making CTPR. The claimed method essentially involved combining a carboxylic acid, an aniline compound, and sulfonyl chloride to obtain CTPR. The defendants, Natco Pharma Limited, had also planned to manufacture CTPR, and their process involved combining a carboxylic acid, an aniline compound, and thionyl chloride to obtain CTPR. The plaintiffs had sued the defendants, saying that the defendant had infringed the plaintiff's patented process for making CTPR under the doctrine of equivalence. Now, the rule for doctrine of equivalence is that even though there isn't literal infringement, there can still be infringement if in an allegedly infringing product or process, a substituted element does the same task in substantially the same way to accomplish substantially the same result. Now, there is no infringement if an essential element is omitted. In other words, this substitute element has to be in a way essential to the equivalent in the patented product or process. Now, given that the plaintiffs had sued the defendants for infringement under the doctrine of equivalence, the issue for the court was to decide whether that was the case. And just to give you a recap, the plaintiff's process was combining an acid with an aniline compound and sulfonyl chloride to obtain CTPR, and the defendant's process was combining an acid with aniline compound and thionyl chloride to obtain CTPR. So, in order for the court to determine if the defendants did infringe under the doctrine of equivalence, the court first looked at the sequence in which the plaintiff's process and the defendant's process had occurred. So, as plaintiff's process simply said combining the acid with aniline compound and the sulfonyl chloride, this combining could occur in various combinations. So, for example, you could combine the acid with the aniline compound first and then combine it with the sulfonyl chloride, or you could combine the acid with the sulfonyl chloride first and then combine it with the aniline compound. And like that, there were various orders in which you could perform this combining. So the court wanted to see whether the combining or the sequence in which the plaintiff's process had occurred was the same as the way the defendant's process for combining the reactants was the same. Now, after looking at this, the court would then look at whether sulfonyl chloride was an essential element. And if it was an essential element in the plaintiff's patented process, they will look to see whether the thionyl chloride in the defendant's process was an equivalent to sulfonyl chloride. So for the first part, to determine whether the sequence in which the plaintiff's process and the defendant's process for combining the reactants was the same, the court looked at the written description of the plaintiff's patent. And the plaintiff's patent in the written description had disclosed a preferable sequence for combining the reactants, which involved combining the acid with the aniline compound first, and then combining it with the sulfonyl chloride. Now, even though the written description for the plaintiff's patent did not limit itself to just the preferable embodiment, the written description had stated that there were several orders in which this combination could occur. And even in the claim of the plaintiff's process, it simply said combining this first reactant, second reactant, and third reactant to obtain CTPR. It did not limit itself to a certain sequence, but yet the court, when interpreting claim 1, had narrowly interpreted it to that of the preferable embodiment. Now, using that interpretation, the court compared it with the defendant's sequence in which the reactants were combined. And there the court noted that in the plaintiff's process, there was just a single reactor used, whereas in the defendant's process, there was 2 reactors. And in the plaintiff's process, where the acid was first combined with the aniline compound and then the sulfonyl chloride, in the defendant's process, the acid was first combined with thionyl chloride, and then it was combined with the aniline compound. So the court noted that there were differences in which the reactants were combined in the defendant's process and the plaintiff's process. Secondly, the court then looked to see whether the sulfonyl chloride in the plaintiff's patented process was an essential element. That is, whether it was necessary for the manufacture of CTPR. And here, based on the written description of the patent and also based on the advice from the scientific advisors, the court found that yes, sulfonyl chloride was an essential element. So the next step for the court was to check whether the thionyl chloride was an equivalent of sulfonyl chloride. So here, the court basically gave deference to the opinion of the scientific advisors. Here, the scientific advisor said that that thionyl chloride was different than sulfonyl chloride for the following reasons. The first one was that thionyl chloride is an inorganic chloride, whereas sulfonyl chloride was an organic chloride, and as a result, it had different physical and chemical properties. The second thing was that thionyl chloride in the defendant's process acted as a chlorinating agent, whereas in the plaintiff's process, the sulfonyl chloride acted as a coupling agent. So in other words, it was performing a different function here. And also the chlorides were performing in a different manner as well, the associated function. Third, you have to look at whether the result that is obtained by the different processes are the same. And even though CTPR was obtained in both of the processes, the court noted that in the defendant's process, you could obtain certain substances that have use in the food and cosmetic industry. Whereas in the plaintiff's process, the other substances that were produced were actually hazardous to the environment. So based on all of this, the court found that there was no infringement under the doctrine of equivalence. So what takeaways can we get from this case? One practical takeaway is essentially to refrain from explicitly referring to an embodiment as a preferred one. Now, even though the Patent Act says that we have to disclose the best mode for performing an invention, we can include it in the written description, but we don't have to explicitly refer an embodiment as being the best one, because then that could allow the court to narrowly interpret the claim into that of the preferable embodiment. The second takeaway is that even though the court had looked at the difference in the sequence of which the reactants were combined, it is unclear whether the difference in the sequence in which the reactants were combined was sufficient to give rise to a finding that there was no infringement under the doctrine of equivalence. So that is a lack of clarity that I had found from this case. But yes, that is all from my side. Thank you for listening. Over to you, Kavya.
Thank you, Nikhil.
Nikhil,
Yes,
one question I have is the process of identifying essential and unessential elements in a claim. Isn't it the second step while determining doctrine of equivalence? Now, when the elements differ, for example, let's say the all elements rule is not satisfied through literal infringement, and there is a differing element, then the next question would be whether this differing element is an essential or unessential element, right?
Correct. Which the court had performed, which the court didn't exactly perform, but they had looked at the written description to see whether, the sulfonyl chloride was essential for performing CTPR in the plaintiff's process. And they had also looked to the scientific advisor's opinions, and they also said that sulfonyl chloride was essential. And then only they looked to see whether thionyl chloride was the equivalent of it, essentially.
Yes. I think in terms of what happened in the case is one thing, but what I am trying to understand is from the point of view of assessing infringement by equivalence. So the first step would be to identify the differing element, then second to see if this is an essential element, and then see if there is the differing element is equivalent, right? That's the
correct. That is the sequence.
Yeah. But I mean, if my memory serves me right, didn't the scientific advisors differ in their conclusion?
No, sir. I think both the advisors had found that in this case that thionyl chloride was not the equivalent as that of the sulfonyl
infringing
chloride.
By equivalence. Yeah.
Yes, it was not infringement under the doctrine of equivalence because they were both different. Yeah.
Okay, fine. So both of them gave the opinion that it was not infringing.
Correct, sir.
Okay, all right. Thanks, Nikhil. Yeah.
Thank you.
Thank you, Nikhil. Next up, we have Gaurav, who's presenting on a recent Delhi High Court judgment Diageo Brands BV and Others versus Great Galleon Ventures Limited. Over to you, Gaurav.
Thank you, Kavya. Do we have this? Good afternoon, everyone. So this case, Diageo Brands BV and Others versus Great Galleon Ventures Limited, was decided by the Delhi High Court early in August 2022. So the judge dispensing the judgment was Justice Sanjeev Narula, and the case citation is CS-Com 87 of 2021. Now, the plaintiff in this case happens to be the proprietor of a design which has a registration number 306-577. Now, this design registration was procured for a bottle which is called a hipster in India. It's also called pocket scotch globally. Now, the plaintiff also asserted common law rights in the trade dress and getup of other hipster bottles, which includes Black Dog, Black Reserve, Black Dog Golden Reserve, VAT 69, and Black and White. The hipster bottles were apparently launched in over 180 countries in 2018. And in India, they were launched in May 2019. Now, the defendant happens to be a manufacturer of alcohol, and it has been selling its alcohol through its principal brand called Goa, or GOA, which was adopted in 1999. There are other variants which include Goa Gold and Goa Spirit of Smoothness. Goa Gold has a market share in its price segment of about 52%. Now, coming down to the facts of the case, this was in February 2021, sometime during the second week of Feb. The plaintiffs realized that the defendant has been manufacturing and marketing its products in 180 ml bottles, basically selling alcohol in these 180 ml bottles. And then the plaintiff says that these bottles are a slavish and fraudulent imitation of the registered designs, and also a dishonest adoption of the trade dress and overall getup of their bottles. Now, on the plaintiff's application, the Delhi High Court passes an ex parte ad interim order on 23rd Feb 2021, restricting the defendants from selling the impugned bottles. Now, when the matter is finally heard, the defendant has sought for vacation of injunction. The products, as you can see here, on the left is the plaintiff's product, which is the hipster bottle for Black Dog. And on the right is what the defendant has been selling. Now, the plaintiff argued that unlike traditional hip flasks, which are broad and short, the hipster is modeled on the shape and proportions of a smartphone. Now, the essential features within their bottle include, firstly, a tall, lean, and sleek look. Number two, a rectangular shape, which is inspired from the shape and proportion of a smartphone. Number three, it has smooth, rounded shoulders and symmetrical edges. Number four, it has a protruding V-shaped neck, which is situated at the middle of both these shoulders. Number five, it has symmetrically raised and plateau-like front and rear walls. Number six, it has two-toned, rimmed and rounded cap. And number seven, it has a dimpled bottom. Now, just to take a quick look at the essential features, I'll just switch to the previous slide. In comparison to what the plaintiff has claimed, the bottle integrates all of these features. The plaintiff went on to say that they have spent a considerable amount of money in promoting the hipster through advertising and social media marketing, and they've generated extensive profits and goodwill. They've sold about 95,000 cases, now each case containing about 48 bottles, worth about 100 crores in just about 1.5 years in India, and that they are entitled to common law rights in the trade dress. Now, the defendant argued that they're a reputed liquor manufacturer. They have sold over 35 lakh cases of the GOA or Goa branded products, again, amounting to closely over 100 crores. They prominently display their mark GOA, and therefore there is no likelihood of confusion. The plaintiffs are not the creators or proprietors of the design, but instead another agency called Love Creative is the real proprietor. They also said that the design is invalid and may be cancelled under sections 19(1)(b), 19(1)(c), 19(1)(d) of the Designs Act, read with sections 2D, 2G, 2J, 4C, and 22(3) of the Designs Act. Now, the defendant, in their first argument, said that the design is not novel or original. To that effect, what the defendant did was they provided a list of prior arts. Now, these were bottles which appeared to be similarly shaped. Now, as far as this is concerned, the court delved into the matter, and we'll take a look at what the court said. But in addition to this, as you can see here, the bottles which are shown up are something that the defendant submitted to prove their point on novelty and originality of the design. Then you have another contention that the defendant raised, which was that the design is functional in nature. And lastly, a contention that there was no overall similarity in the trade dress. Now, the issues before the court was, number one, who is the proprietor of the registered design? Two, what is the legal effect of registration of a design when deciding the relief of grant of injunction? Number three, has a prima facie case been established to show fraudulent and obvious imitation of the plaintiff's registered design so as to warrant an injunction? Number four, has the defendant demonstrated any ground of challenge enumerated under section 19 of the Act? And if so, what is its effect? Lastly, is there any similarity in the trade dress or get-up constituting pass-off? And if so, can an injunction be granted on that ground? Now, in taking a look at all the issues which were raised, the court arrived at the following conclusions. Firstly, it said the plaintiff is the registered proprietor. Now, in order to support this, the court said, when a work is executed for one person by another, the first person would remain the proprietor of the design. And no point will the person who executed the work retain any rights or title for the work. Here, Diageo had basically paid this agency called Love Creative to design the bottles. And the defendant raised this argument saying that Love Creative was the real holder or real proprietor of the design and not Diageo. Now, the court did not agree to this, and they held that the plaintiff is the registered proprietor. Secondly, the argument in respect of the effect of registration, the defendant had said that the registration was very recent and therefore it could not be considered. But when the court took up this issue, they noted that registration, first of all, understandably is not a prima facie evidence of validity, which is true. And this is something that they accepted. But the recency in registration of a design would not be a matter of consequence, is something that the court opined. Now, when it comes to determining and checking for infringement of designs, the yardstick of determining infringement is visual effect or appeal to the eye of the customer and ocular impression. And it is to be taken as a whole. The test is not to look out for subtle dissimilarities, but rather to see if there is substantial and overall similarity in two designs. Now, when the court took a look at the bottles of the defendant and the plaintiff, they said there are only 3 points of difference. Firstly, in the defendant or the defendant's bottle, there is a crest-shaped logo embossed on the upper portion at the front, whereas the hipster bottles of the plaintiff are plain. Secondly, that the defendant's bottle is a few millimeters shorter, slightly more bulbous than the hipster. And thirdly and lastly, that the neck of the product is about 1 millimeter shorter. Now, the court after observing all of this, said that the defendant's product is actually deceptively similar to the plaintiff's registered design. And that the defendant, it also noticed that the defendant was selling its product in a different package, which was distinct from the plaintiff's registered design and trade dress. In respect of the cancellation of the design, the grounds which were raised, the court said that, number one, novelty is something that has been established because the plaintiff was not able to prove that there were prior art which were similar to the bottle, that the design of the plaintiff was published could not be proved. And also, in respect of section 4C, which talks about registering designs which are a combination of known designs, or also known as mosaicing, could not be accepted in this case. Lastly, the defendant's challenge to the validity of the product itself could not be held, and the defendant's product is similar. Now, when taking a look, what the court said was, although a bottle or hip flask is not new or novel by itself, they have been used for the purpose of carrying liquid since time, and their design lies in the public domain, accepted. But the innovation and novelty of the design, as conceptualized in the mind of the proprietor, is in the shape and configuration as applied to the bottle. Now, having said that, another argument, which in fact most defendants tend to raise when a design registration or a design infringement is brought into the question, is with respect to the functionality of the design. So as probably most of you are already aware, a product which has a functional nature cannot be registered as a design. Now, in order to understand this functionality, what the court said was, firstly, there should not be a dissection of individual features of a design and try to find them individually in each prior art. Instead, all the features should be seen as a whole. Then it is well within the realm of the possibilities that existing features of known designs can be combined in an unseen manner, which can result in a new and original design. Lastly, mosaicing of pre-existing designs is not a defense to seek cancellation of registration. Defendants will have to show one single prior art to claim prior publication. For the ground of functionality to succeed, the defendant must establish that the plaintiff's registered design is the only way possible to manufacture or create a given article, considering the functional requirements of the product. Merely because form has relevance to function, it does not entitle a proprietor from registering its design. Now, the test in law for cancellation with respect to designs is that the design is dictated solely by function. In the current case, which was not the case, it's quite possible that an article has both design aspects and functionality aspects. In such a case, functionality has to be actively not considered while considering a design's novelty. Now, in respect of the trade dress, the distinctiveness of a trade dress is not to be perceived by its individual elements in isolation, but has to be seen as a whole to determine whether its essential features are distinctive enough to become a source identifier. A passing of action is basically based or founded on 4 essential ingredients. 1, use of a mark in the trade for sale of the goods. 2, generation of reputation and goodwill as a consequence of trade. 3, association of the mark with the plaintiff's goods. And number 4, misrepresentation sought to be created by the defendant by its use of such mark, so as to deceptively portray that its goods originate from the plaintiffs. Now, having taken a look at all of this, what the court said was that a 2-toned rimmed and rounded cap bottle has been widely used in the industry and is not unique to the plaintiff. Therefore, in terms of the passing of action, a remedy could not be provided to the plaintiff. While for the rest of the issues which were raised, the court held the case in favor of the plaintiff. That's about it in terms of this case. Thank you. And if you have any questions, please do feel free to.
We have a question live.
Okay.
Yes.
Hi, Gaurav.
Hi, sir.
Okay, can you hear me? Yeah. Okay.
Yes.
So first question I have is, can you get Hipster online? Can you buy it online? Is it available? Looks
I'm
like
sorry,
a nice product.
Hipster. Oh,
Can you buy Hipster online?
I believe certain states have it. I'm not sure if Bangalore has it.
Okay. Does it come filled with alcohol, or it's just an empty flask kind of? Any idea?
I think it's I think they come together. So they go to the party together.
Is that so? Oh, is that so? Okay. All right. So now, one question I happen to read this case. So one question I have for you is, I believe the court has clearly differentiated between assessing design infringement and assessing passing off, and this has been discussed in multiple cases, and the court in this case once again reiterated. So for the benefit of the people who are listening to us today, so I just request you to clarify what is the difference in process of assessing design, and whether what forms part of a registered design would also be considered for assessing passing off.
Now, essentially, when you're talking about a registered design and also infringement, it's very important to remember that the infringement is not taken from a product to product perspective, but rather from a registered design to product perspective. So what forms part of the design register is what you will have to consider when looking at design infringement, and not what somebody is producing or manufacturing, right? So you will have to compare these, and only then a ground must be made. Now, in this case, at least in Diageo, what the plaintiff was claiming, what they were manufacturing, was very much the same product. So there was sufficient ground for the plaintiff to actually get this decision in their favor. Now, as far as passing off is concerned, as we've clearly discussed, when we speak about passing off, we are looking at the trade dress as a whole. So now here, in this case, the plaintiff, as we spoke about earlier, was producing these hipster bottles with alcohol under different brand names, including VAT 69, Black and White, the Black Dog, Golden Reserve, etc. So when you have all of these different names and possibilities of combinations of colors, etc., you will not be able to establish a passing of action in view of the design infringement. So it is not something that you will actually come across. Of course, this is something that is raised very often in almost all design infringement issues. But yeah, the court has again very clearly held that these are two entirely different and distinct issues at hand.
Okay. I'm sorry to reiterate my question again. As per my understanding, if you are claiming design infringement and passing off in the same case, my understanding is that elements that form part of the design that has been registered would be excluded for determining passing off. Am I right in saying that?
Correct.
Or am I
Correct. Yes. Because when you're looking at a design, you're effectively looking at how the product looks as a whole, in terms of its either shape and configuration or surface pattern and ornamentation, whereas that would not be the case for a trade dress.
Okay, but normally when you claim rights with respect to trade dress, you would be claiming the trade dress with respect to the entire product, right? And that includes even the shape and configuration. So am I right in understanding that shape and configuration will be negative for determining passing off, or shape and configuration that forms part of the design registration would also be included when you do a product-to-product comparison for passing off of trade dress?
So as I see it, and at least in my opinion, I think this would be again distinct, because the shape and configuration would not be excluded. Would be excluded in passing off.
Okay. All right. Yeah, that's clear. Thank you.
We also have, I believe, a couple of questions online. So
Sure, please.
okay, is it that only publication is considered prior art? Isn't prior use also prior art? This question is by Nirmala, and yes, publication is considered prior art, and prior use is also considered prior art. If you are able to establish prior use, then it is a ground that can be used for cancellation. And the second question is, functionality is for the whole bottle, I guess, or is it for individual parts? So functionality is for the bottle as a whole and not for its individual parts or components. So I hope we have that clear. All right, off to Kavya.
Thank you, Gaurav. Thank you, Ms. Nirmala, for your questions. And thank you, sir. Next up, we have Sushma, who will be presenting patent and design statistics for the month of September. Over to you, Sushma.
Thank you, Kavya. Good afternoon, everyone. I'll be presenting patent and industrial design statistics for the month of September. The graph here represents both patent and industrial design statistics for the month of September. The colors represent each territorial jurisdiction. From the bottom, it represents Delhi, Mumbai, Chennai, and Kolkata. A total of 7,482 patent publications happened last month, out of which 2,376 accounts for early publication and 5,106 account for ordinary publications. Out of 2,376 early publications, 590 early publications happened from Delhi jurisdiction, 478 from Mumbai, 1,122 from Chennai, and 186 happened from Kolkata jurisdiction. Out of 5,106 ordinary publication, 2,104 ordinary publications happened from Delhi, 1,245 from Mumbai, 1,585 from Chennai, and 172 from Kolkata jurisdiction. With respect to examinations of patents, a total of 6,108 FERs were issued, out of which 2,596 FERs were issued from Delhi, 1,209 from Mumbai, 1,871 from Chennai, and 432 FERs were issued from Kolkata jurisdiction. Last month, 3,372 patents were granted, out of which 1,369 patents were granted from Delhi jurisdiction, 554 from Mumbai, 1,070 from Chennai, and 379 patents were granted from Kolkata jurisdictions. Indian Patent Office registered a total of 700 industrial designs last month. All the data presented here were collected by Indian Patent Office official journal from 35th to 39th issue. For weekly statistics, check out BananaIP IntelliPedia IP News Center. Thank you.
Thank you, Sushma. Next up, we have Ipshita, who is presenting on Vasundhara Jewellers Private Limited versus Kirat Vinod Bhai Jadwani. Sorry, it's a recent Delhi High Court judgment. Yeah, over to you, Vasundhara. Ipshita.
Good afternoon, everyone. I am Ipshita Bhattacharya, and today, on behalf of the trademark and copyright team at BananaIP Councils, I have come up with a case recently decided in the Delhi High Court with regards to the trademark. The case that we have today is Vasundhara Jewellers Private Limited versus Kirat Vinod Bhai Jadwani. The case was decided on 21st of September 2022. And it is very relevant for us as it decides on the basis of deceptive similarity between two device marks with similar text and the significance of it in present context of trademark jurisprudence. So the plaintiff that we have today is Vasundhara Jewellers Private Limited, and they have been involved in the business of jewelry making. So they have high-end jewelry that they have been selling and manufacturing and designing since the early 90s. And they have been using the mark Vasundhara since 1st of January 1999. And they have 3 device marks, as we can see, Vasundhara, the label V, and the label V with the mark Vasundhara Jewellers. All of them registered as device marks in class 14 and have been used since earliest is 1999, and since the latest, the V mark has been used since 2016. So along with this, they also have 7 different domain names registered to themselves called Vasundhara Jewellers, Vasundhara.com, Vasundhara.com, Vasundhara.in, VasundharaJewellers.in, VasundharaJewellers.com, and VasundharaJewellers.in. The defendant that we have is Kirat Vinod Bhai Jadwani, and they have 1 mark registered in class 25 as Vasundhara Fashions, and it has been in use since 2nd of December 2020. And they have a domain name registered under the name vasundhara.business.site. Now, they have registered for a label mark, again, device mark, with the picture of a coconut tree leaf with Vasundhara Fashion written in it. However, their physical store, which is in Gujarat, has a different kind of a mark on their stores. They also have business that they conduct through different e-retail stores like Flip. Not Vasundhara Fashion, as they have registered for it. Now, the contentions that we find here is that the proprietors of Vasundhara Jewellers, the plaintiffs in this case, they say that they are the prior registered users of the mark Vasundhara with the same spelling as the defendant is using, and they have recognizable goodwill because they had done recent shoots for high fashion jewelry, including big names like Janhvi Kapoor. Now, they allege that the marks are deceptively similar, and because clothing and jewelry, the defendant are in the business of clothing only. So because clothing and jewelry are very aligned to the fashion industry, and therefore these goods are considered to be and can be considered to be allied and cognate goods. And although all the 3 marks registered by Vasundhara Jewellers are device marks, along with the websites and domain names that they have, the essential feature of their device mark is the word Vasundhara. That's the recognizable element common throughout all their marks and the branding that they use. Therefore, the use by defendants of the words Vasundhara leads to infringement, passing off, dilution of their mark, and creates an unfair competition between the both the proprietors, especially the marks in the fashion industry. Now, they had said, the plaintiff in their contentions, that they have no objection if the area of operation of the defendant is just limited to Gujarat on a business-to-business model instead of going cross-border through their e-retail stores or going for an all-India shipping and delivery. Now here, the defendants contend that class 14 in which the plaintiffs are registered and class 25 in which the defendants are registered are very different classes of goods. They might be related to the fashion industry, but did not necessarily relate to the same customer base or same strata of the society. The defendants allege that high fashion jewelry is something only a few people with access to that kind of wealth can use or even buy. However, the clothes that they sell are in a very different price range, where the highest price of their clothing go up to 1,000 rupees. Furthermore, their business is mostly a business-to-business model, mostly confined to state of Gujarat, meaning that 80% of their work happens to be supplying clothes to other businesses within Gujarat. Only 20% of the business is done through e-commerce, for pan-India customers. That too for clothes which are below the range of 1,000 mostly. The other contention that the defendants put out is that the plaintiff has a single shop in Pitampura, New Delhi, which does not even have a pan-India reputation. They're a local shop in New Delhi, known in New Delhi, and their allegation that they are working with high fashion houses and celebrities is false, because the advertisement that they are putting out for their jewelry is basically a fashion ad by a fashion designer in which their jewelry was used. It was not an ad for their jewelry per se, or a sponsorship of their jewelry, just something that the model Janhvi Kapoor had to be wearing while doing the shoot. Also, they contend that the name Vasundhara is a very common name in India. Given the fact that there could not be any exclusivity over a name which is very common in India, and it cannot be contended to be an essential feature, given how commonly people relate to it across different states in India. Furthermore, that they have mentioned that the defendant's mark is for a different class, whereas the plaintiff's mark is for registration in class 14, and also as device marks, where they have not claimed any specific rights over the word mark, the literal element that is Vasundhara. So with these contentions, the Delhi High Court under Justice Naveen Chawla had given the judgment that, keeping in mind that plaintiff's mark, all the marks are all device marks, and there has never been an exclusive claim over the word Vasundhara. And given how trademark jurisprudence has been and how it is decided, that you have to exercise exclusive right over a mark only when it's as a whole, and one part cannot be claimed by dissecting the entire mark to be the essential feature. Furthermore, Vasundhara is a common name in India. It is not descriptive of the goods either for plaintiff or for defendant. In that context, Vasundhara is almost an arbitrary use of a common name for the goods that both plaintiff and defendants are selling. Also, the goods that are sold by plaintiff and defendant are very different. They exist in different classes of the trademark registry. They also cater to different classes of the society. Furthermore, given that both the marks are device marks, there are visual differences between the conflicting marks. So visually, when perceived by a person will not mistake the plaintiff's mark to be the defendant's mark or the defendant's mark to be the plaintiff's marks. Also, the area of operation for both the businesses are different, and both the proprietors have different channels of trade, different channels through which they conduct their business. So taking into consideration all of these pointers, also referring to the case of Register of Trademarks versus Ashok Chandra Rakshit and South India Beverages versus General Mills Marketing India, the Honorable Justice Chawla has observed that though it is equally well settled that for a device mark, the essential feature of the same is equally entitled protection, at the same time, it has to be remembered that in extending such protection, the party does not lay claim of exclusivity in a mark to which otherwise he would have been unable to do so. The possibility of the proprietor attempting to expand the operation of this trade cannot be ignored or overlooked. Keeping this observation in mind, the case was decided in favor of the defendant, Kirat Vinod Bhai Jadwani, stating that mere similarity in literal element of device marks is not enough if there are visual and other differences in terms of mode of operation, areas of operations, the trade channels, and the customers catered to, and the geographical area that is within the sale of business. In keeping these factors in mind, a decision can be made to allow registration of two similar literal elements of device marks in different classes. So it is very relevant for us who are defending examination reports with a section 11 objections by the examiner. This case becomes very helpful and handy in those regards. So I felt it was very relevant for us to discuss this today. With this, I thank everyone. Sign off for today. Thank you.
Thank you, Ipshita. With that, we come to the end of today's monthly updates meeting. We have received a few questions from the audience. Mr. Naveen has asked if this video would be available online. To answer that question, yes, this video will be available on YouTube, as well as we will make shots of these videos, like short videos, and publish them on our LinkedIn profile as well. So, yeah, all right. Thank you for joining us offline as well as online, and hope you all have a great evening. Thank you.